Good morning. For the record, this is the LCC Subcommittee on Data Practices. And today's agenda is relatively short, but it's important for us to discuss. Before we get too far into that, I would like to seek a motion to approve the minutes from the last meeting. Senator Bigham. I don't know why I have such a troubled problem with. I wish I could say that and agree with you. Senator Bigham moves the minutes. All those in favor say aye. Opposed? The motion carries. Today we're going to have an update and a review of Minnesota Government Data Practices Act and how it involves and relates to cloud-based data language. As you know, the cloud is being used more and more for data collection and retainage, and yet at the same time, we're trying to catch up to determine whether or not this is an appropriate tool for record keeping for government agencies. Mr. Matt Ealing from Mincoji will be addressing us, giving us a few thoughts and observations on how cloud data management works, and perhaps even some suggestions to us. We're not going to be voting on anything. There is a proposal, at least for the sake of this discussion in writing. It's a document SC 5645-2 that we'll be getting to a little later. But Mr. Ealing, would you approach the testifying table? Oh, and before you begin, I'm going to have Priya give us a review of the language before us and what we're going to discuss today.
Mr. Chair and members, there's one draft in your packet, SC 5645-2, and it is a working draft at this point. As you may recall, at the previous subcommittee hearing, Mr. Ealing presented two potential options at the time, and both options included some concepts like right of access, computer capabilities, and third party, which prompted a lot of discussion from this subcommittee about the parameters of those concepts and whether they were confined or well-defined. And so since then, the stakeholders have had some more discussion with which Mr. Ealing can talk a little bit further about. And so this proposal moves away from those concepts and attempts to perhaps more directly get at the problem that stemmed from the DEED Greater MSP informal collaboration with the Amazon bid draft process. So looking at the draft, it states that government data includes data collected, created, received, maintained, or disseminated through a government entity's use of an electronic file sharing or storage system, regardless of whether that electronic file sharing or storage system is owned, operated, or managed by a person other than the government entity. Then there's a brief definition of electronic file sharing or storage system, and this is one of the potential areas for further work in progress, and I believe the stakeholders also have some other discussions that are ongoing during the next month. So I think Mr. Ealing can probably speak to some of that.
Thank you, Ms. Primo. Mr. Ealing.
Thank you, Mr. Chairman. Matt Ealing, Minnesota Coalition on Government Information. I'll provide a brief update on the status of where this discussion has been since we last met. Since the last hearing, as Senate Council has identified, we've worked on some refinements to the options that were presented, and we took into consideration feedback from the Data Practices Office and other stakeholders around questions of the clarity of that language, and have tried to provide more refined language. Since we're not trying to open up new territory to the Data Practices Act, but rather to reaffirm that the Data Practices Act covers this kind of cloud-based data under common understandings of how Chapter 13 works, we've tried to find more narrow language, and appreciate Senate Counsel and House Counsel in that undertaking. When our board started to look at how to refine this, we started with looking at advisory opinion guidance provided by the Commissioner of Administration about the interaction of government entities, non-governmental computers, and when that creates government data. Subcommittee members will have a packet available to them of various advisory opinions, and we've excerpted sections that we think are applicable to this discussion. For those of you who are not familiar with the advisory opinion process, this was implemented in Chapter 13 in the early 1990s, and what it's done is allowed the Commissioner of Administration to issue advisory opinion guidance about how Chapter 13 works. And as a consequence of that, there's a very large body of this advisory opinion guidance out there, and it has allowed various questions to be answered at an advisory level rather than going to litigation. So you have a very large body of this information to rely on. And if you look at the packet, you'll see some of the key concepts that we've highlighted that are relevant to this discussion, including ideas such as government data is really extremely broadly defined by the existing definition in Chapter 13. Government data does not need to be maintained within a government facility or on a government system, for instance. And government data includes electronic data used by government employees on non-governmental computing devices when they're conducting government business. So in the opinions, you'll see, for instance, existing guidance that says that, for instance, the mayor of North St. Paul once used his own personal email account to send and receive emails about government business, and that was considered to be government data under the statute because he was conducting governmental activity. The same was true of members of the Duluth Airport Authority who were using their own personal cell phone devices to receive government or to receive data pertinent to their government functions, and thus it was government data under the statutory definition. And so we've tried to apply that line of logic to the language you see here regarding government use of file sharing systems that are private, not owned by the government itself. So last week there was a meeting of various stakeholders to discuss this draft language that included Minkoji, representatives from several government entities, several longtime data requesters, the Minnesota Newspaper Association, and the Data Practices Office. And most of that discussion really focused on the scope and impact of the general definition of government data. It didn't get too much yet into the specifics at play in this draft. So a follow-up meeting has been set for November 20th. At the League of Minnesota Cities at 10 a.m. We'd welcome anyone who's interested, legislators or other stakeholders, to attend if you're interested in following this further. So that's our update right now, Mr. Chairman.
Thank you, Mr. Ealing. Is there any questions by the panel? You must have hit it out of the park, Mr. Ealing. You answered all our questions. I am kind of concerned, though, in the event that I'm kind of surprised that government data can be held and retained in a non-government infrastructure of some sort, even a cell phone. Does that mean that, does that still follow the requirement that much of this information is open to the public? And then would you have to go back in the case of someone having a public record on somebody's private cell phone? How does that work when a member of the public wants to have a copy of something? Who's the contact person? Usually there's a designated person in a government agency that's supposed to be the contact person or the one ultimately responsible for sharing data and the appropriate sharing of certain information and the protector of other information that is considered private. How does it work when it's on someone's private computer or private cell phone?
Thank you, Mr. Chairman. There is, as you'll see referenced in a couple of these excerpts, there's an understanding that stems from several other data practices advisory opinions that have been iterated over time, that if you have personal information, say you're a government employee, and you have purely personal information, say you have emails to your family members about when you're going to come home for dinner, that falls outside of the scope of the definition of government data as interpreted by the Commissioner of Administration. So there's already advisory opinion guidance that kind of cabinets that personal data off from government data. So that's the first thing I would note. And the second thing is that in the event that a government employee is using non-governmental technology to create and maintain government data or to receive government data, the data request still has to go to the government entity. The government entity then makes a search based on the scope of the request that the requester has put in. So if they talk to someone, say a school board member, who's been following a particular issue that a data requester is interested in, they can ask that person where they maintain data relevant to that request. And if they happen to have it on a personal device, then they're obligated to turn that particular information over under Chapter 13.
Mr. Ealing, I'm asking questions because I don't think anyone else is, but the question in the event of, let's say, a township or a political subdivision, I believe it's 7,500 people or less do not need to satisfy the same retainage requirements on government data, such as a township. And when we're looking at this subject, I would tend to think that cloud management would be relatively cheap, especially for a small political subdivision. Would you think that the cloud makes it easier for a small political subdivision such as a township to actually use that resource, and then they can be included with all of the other government political subdivisions that are required to do so?
Mr. Chairman, that is an interesting question. As you correctly observe, most Minnesota townships are not covered by the Data Practices Act, with the exception of some urban townships. We have heard from members of some of those townships. We had a gentleman come into our board meeting a couple months ago who's in a township and can't get information from his local township board, for instance, because there's no Chapter 13 coverage. So it's an issue that has come up. I will defer to the IT professionals who are in the municipalities and the townships as to whether or not that would make their job easier, but I think it's an interesting question worth pursuing.
The reason I bring it up is that we've had this discussion before in legislative committees, and the argument has always been, at least with a township, that they would say, well, we don't have the same resources as other political subdivisions, therefore we should be excused. However, there's a lot of personal or decisions made by smaller political entities that have a direct impact, sometimes even more of an impact on individual property owners or taxpayers than what a larger political entity would have. And so now that we're expanding our resources and the infrastructure is becoming cheaper and more easily attained, that might be another area of law that we should perhaps review and consider in the future, so that the public has a full opportunity to know what government on all levels is doing for them and sometimes to them. Is there any other questions by the panel? Well, Senator Scott, or Representative Scott, sorry.
Did you call me Senator?
I made the mistake of promoting you.
Okay. Well, that's up for debate. Thank you, Mr. Chair. Mr. Ealing, all this is great if we know that these things are classified as government data, but I was part of a discussion a few years ago about how long that should be retained, because it's of no use to anyone if it's only being retained for 30 days or shorter periods of time. So I'm wondering if you could address that issue, if your organization has taken up any more discussion on the retention period. Thank you.
Mr. Ealing.
Thank you, Representative Scott. There's, I guess, a couple issues in play. As we discussed with stakeholders at the meeting last week, this particular proposal doesn't get into the retention question. It's purely a definitional question of government data, to ensure that this category of information that's being more commonly used will fall within that government data definition. And as you observe, the way to think about government information policy in Minnesota is sort of like a funnel. At the large end of the opening is the definition of government data, which is the most expansive statutory definition. So everything that fits in that definition goes in the top of the funnel. As you go down the funnel, then you hit Chapter 138, the Records Retention Statute, and that has a definition of government record that government data can be a part of. And then it sets out retention requirements and procedures for retaining government data in the form of government records. And that doesn't apply to all government data, but it applies to very specifically defined records that either, for the most part, the records retention is set out by government entities and then approved by the records disposition panel. So that's sort of how the funnel works. So to the extent that anything that needs to be maintained under a records retention schedule is housed in a cloud-based Dropbox, for instance, it would still need to be maintained. If it wasn't on a records retention schedule and it's in a cloud-based Dropbox, it would not need to be retained. So that's a discussion that's separate from this, but it's a very important discussion. As legislators and the public are probably aware, the retention issue came up in a very large way last week in another hearing here at the legislature, where the legislative auditor had found that there was no information that DHS had in its possession that documented how millions and millions of dollars were spent. And as you recall, Representative Scott, you had brought a retention bill around setting parameters for retaining correspondence by government entities. And the legislative auditor came and testified to the importance of making sure that certain information was maintained so that decision-making could be documented. And now we have a situation where millions of dollars of state money has been used and there is no documentation of how that came to pass. So the retention issue is important, but it is separate from this particular proposal.
Representative Scott.
Thank you, Mr. Chair. Thank you for that explanation. And I would hope that that's something maybe this commission can take up, because there are all kinds of practical examples where that information is still needed. And I think the notion of entities being able to say that it's just too expensive to store all that, I think it's becoming less and less expensive. And we can now see the value in the accountability piece for holding on to that information at certain amounts of time. And if I remember from the discussion around defining correspondence and so forth, the records retention piece, it was kind of a smattering of different time periods to save different types of information or correspondence. And, in my discussion of that bill, it said, if the current records retention schedule said for that type of correspondence to be held in paper for 6 months, let's say, then electronically it ought to be held for the same amount of time. And to me, that just seemed to make logical sense. But it'd be something that I think that this commission should look at in the future. Thank you, Mr. Chair.
Thank you. Any other comments on this subject? Yes, Representative Muller.
Thank you, Mr. Chair. And maybe just more of a comment than a question, too, when we're talking about cost of storage, which I know, Mr. Ealing, is not really what's in front of us today, but just wanted to point out, too, that it's not just the cost of the storage, and maybe that is getting cheaper with the cloud-based services, but it's the cost of compliance when you get those data practices requests and the staff it takes to sift through some of the information to find what it is that's being requested and determine what should be turned over. So I just don't want us to lose sight of the fact that the compliance cost is also still something that we should consider when we're looking at expanding or changing any of these things. Thank you.
Thank you, Representative. Any other comments? I think we'll close on this subject, and we're going to go to another area as we approach facial recognition technology. But before we begin, there's a video that will help us focus on some of the issues that we obviously are going to have to address sometime in the near future. It's a news account, and it'll give us a little taste of where we're going. As far as the previous issue, there may be, this whole discussion is basically getting us into an area as an introduction The document that we had, the SC 5645-2 that I referred to, is kind of an introduction to putting some thoughts on paper and giving us a starting point for discussion. And as we proceed, even by next meeting, we'll be inviting members of the public to participate. If there's businesses or other government entities, after they review that, if they can help us give their perspective, we would welcome that. So please prepare for that if you're in the audience and wish to participate in the discussion by next time. Are we ready to go? All right. Bring it on.
Right now, we have 3 really good examples of facial recognition being banned within a specific city. San Francisco is one of them, another one is Oakland, and the third is Somerville in Massachusetts. There's also a bill being discussed right now for the state of Michigan, which is the first statewide challenge to facial recognition. Within the last couple of years, we learned that major cities within Michigan, including Detroit, have had facial recognition deployed for years. And this is an important moment for the U.S. because it's the first time we're starting to see challenges about surveillance and biometrics data being captured, stored, and used for the purposes of law enforcement being transferred into the courts.
Today we're in our mixed reality studio to get the big picture on facial recognition. Okay, Liz, so when an artificially intelligent facial recognition program sees a human face like this, tell us what it's looking for first.
Well, there are lots of methodologies that we can look at, one in particular called OpenFace. The first thing it needs to do is find out whether there's even a face in the photo. And it does that by looking for 68 different facial landmarks that typically represent what we would think of as a visibly human face. Within those 68 different groupings, we're looking for edges or gradients. And the edges typically represent a group of pixels that's the same color or that shifts from a darker color to a lighter one. In the OpenFace paper, there's particularly 8 different landmarks that represent a human eye, and many others comprise an eyebrow or a mouth or a nose, anything along those lines that you might see when you look in the mirror. Well, now that we know we have a human face, the goal is to get it into a format that's uniform. And using these 68 points as anchors, we can then scale or rotate or even adjust the angle of the individual's face.
So this is going to allow the program to be able to make it bigger or rotate it a couple degrees and still be able to effectively understand what it's looking at.
Exactly. We want every face that we're trying to predict on to be effectively similar enough that we know things are in the same spot. The challenges come in whenever your training data is different from what you're trying to predict. So that could mean if all your training data is done in low light and you have a really sunny day, then it's going to be really difficult to predict a match. If it's something as simple as you have on a pair of sunglasses, that removes a lot of the landmarks and makes it a lot harder to predict. Well, the next step is to try to extract information from that face. And we do that by passing the photo through a neural net. Each layer, until the last one, is going to try to extract features and then represent them in a mathematical form.
So Liz, where are these programs getting the data to match these faces to?
Well, usually a facial recognition system has a database of photos that have already been run through a neural net, meaning they're already translated into math, into multidimensional coordinates. Now, if I have a database and I know that this mathematical representation looks like Liz O'Sullivan, then I can also take this new photo and try to figure out how close that vector space is to the resulting vector space of my new photo. If it's very close, then yes, it might be Liz. If they're very far apart, it's likely it's somebody else. People are starting to realize exactly how powerful this tool is, and in some cases we're finding out that law enforcement and federal agencies have been using it for some time without our knowledge or consent. In a lot of cases we're finding out that this technology doesn't work as well on people of color or women or gender fluid or non-binary people. So this is important now for us to take a moment to understand fully exactly what we want our civil liberties to look like in the U.S.
Thank you. Mr. Ealing, would you want to join us at the table? And after Mr. Ealing is finished, then we're going to hear some comments from Commander Scott Gerlicher after Mr. Ealing is finished. Mr. Ealing.
Thank you, Mr. Chairman. Matt Ealing, Minnesota Coalition on Government Information. We appreciate the opportunity to provide some introductory comments about this area, and appreciate Commander Gerlicher here being here to offer comments on behalf of the MPD as well. This is an area that has yet to be regulated for the most part by this legislature and this state. There's a reference to facial recognition regulation within the drone bill. You'll see some language in there about the possible use or not, or prohibitions on use of facial recognition in drones. But as a overall matter, this has not been touched by the legislature. So we wanted to highlight some areas of policy that the legislature may consider looking at as it moves forward on regulating facial recognition technology. As you saw from the video presentation, the way the technology works is essentially to have two sets of data. You have one set of data that is an unknown image, a photograph or video image of an individual whose identity you do not know. Then you have a database of known images, images that are correlated to known identifying information. And then the algorithm in the facial recognition program is essentially cross-matching those images to see if they can identify the known image with the unknown image. So this technology has been in development for many years. It's only recently become sophisticated enough to be commercially implemented, and you start to see within the last couple of years private companies using this. Facebook, for instance, uses facial recognition within the database of faces that it has, that its users have provided as a way of identifying and tagging photographs, for instance. And even marketing companies are using facial recognition in cameras embedded into billboards to be able to target ads to individuals. So there's a whole raft of commercial applications that are out there. And then the government is starting to be able to utilize this and is looking to utilize it. So common to many of the facial recognition applications that government is looking at is one particular task, and that's being able to automate the process of this image review to be able to search much bigger data sets than an individual person could on their own in a reasonable amount of time, or else to analyze this facial recognition, or excuse me, facial database set at a much greater speed, or perhaps to do this even without any kind of human intervention at all. So that's largely why this technology is of use to potential government users, but there are other uses as well that government's interested in. There's a program that DHS and other human services agencies around the country are starting to look at, called electronic visit verification, which is essentially fraud prevention in who can utilize Medicaid funded services. They're looking to better identify who those persons are, which I can get into in more detail later. But as this technology is being operationalized by government, we believe this is the time to be proactive in trying to regulate it. So some of the policy questions that will arise are as follows. If you look within the realm of investigative image matching, the use of image matching by police and law enforcement agencies, there's obviously an interest on the part of law enforcement to have an automated process to do some of this image matching. And the regulatory questions that will arise are of sort of two types. First is, what is the accuracy of the systems that are being relied on to perform this image matching? And what are the processes that will be triggered by having a positive image match identification coming out of a facial recognition system? The question of accuracy has been one that's been a point of discussion in recent years. There's various academic studies that have raised questions about the system accuracy of these various commercially available systems. And so to the degree that system outcomes are relied upon to trigger specific outcomes in the real world, say a positive identification in a facial recognition program results in an arrest happening, this is an area for looking at for potential regulation. So if you look at some of the documentation that Mr. Neumeister has provided in his written comments, he notes a GAO report. The GAO has made recommendations to the FBI at a federal level about best practices for contracting with facial recognition vendors and looking to accuracy requirements within those programs. And then the other part of the discussion is around consequences of the positive image matches. So there's questions that arise such as, Will a police department rely solely on having a positive identification come out of a facial recognition system to trigger an arrest? Or will the department want to rely on an individual police officer's review of that determination before any kind of probable cause to conduct an arrest or other kind of law enforcement action happens? So those are the questions, I think, that arise in that area. Another set of questions surrounds what databases will be allowed to be used and reviewed as part of facial recognition programs. You can ask questions, for instance, about the use of the state driver's license database. Will that become, or has it even become, I think there's research to be done on that question, has it become a data set used for facial recognition matching? So if you look at the current classification of driver's license photographs in Minnesota, that's set out in Minnesota Statute 17107, they're classified as private. But there is language in there saying that that private data can be utilized by certain government entities. So law enforcement entities, public defenders, coroners are among the entities that can utilize that information. And so the question then becomes, and I think it's a research question for everybody to find out, have there been or has there been any interest amongst those entities in utilizing that driver's license database set for facial recognition purposes? You can also look to Minnesota Statutes 171.12. This governs where driver's license images may be shared outside of Minnesota. And if folks recall, a couple years ago in the grand bargain around Real ID, the state set up two forms of identification. So there's the Real ID compliant driver's licenses and the non-Real ID compliant driver's licenses. Within the statute, there's regulations that say that you cannot share driver's license information outside of the state of Minnesota after the enactment date of the Real ID law. So within that subset of driver's license photos in non-Real ID compliant licenses, there's some regulation about who these photos can be shared with. But I think there's other questions to investigate about the other set of driver's license photos in Real ID compliant licenses. The most controversial application of facial recognition is the integration of facial recognition technology into municipal and government camera sets to enable real-time tracking of individuals. And again, this is something that's only been technologically possible recently because as the scale of computing power has increased, there is now the possibility to do this. And this is one of the main civil liberties concerns that people raise. So if you look at China, for instance, in mainland China, there are very extensive camera networks integrated with facial recognition systems, artificial intelligence, and the purpose of those systems is to precisely track the location of individuals over time. If you watch footage of the protests going on in Hong Kong, the protesters are acutely aware of this because they are cutting down light poles that have surveillance cameras on them. They're appearing in public wearing masks. So they're acutely aware of the possible misuse of this technology. In the metropolitan Twin Cities, for instance, there are pretty extensive networks of video cameras that already exist. You can look to a MinPost article that was written a couple of years ago that tracked the location of police surveillance cameras in St. Paul and Minneapolis, and you can see how pervasive that network has become. And so that opens up questions about what kind of technology will then be piggybacked on top of that network of cameras, and will it be allowed or enabled to conduct real-time surveillance of the location of individuals. And this gets to larger Fourth Amendment questions. So even if that is technologically possible, it opens up the question that's beyond a policy question. It comes to a constitutional question. Is something like that constitutionally feasible or allowable in the United States? So if you look at case law under what's called the plain view doctrine, generally items or persons appearing in public don't have a reasonable expectation of privacy under the Fourth Amendment. However, we are now at a turning point that we have not been at before in this country, where the government could potentially have a much more invasive and comprehensive ability to look at where individual citizens are at any given time. And this is dealt with to a certain extent in a 2012 Supreme Court U.S. Supreme Court case called Jones. There's a concurrence by Justice Sotomayor that opens up questions about what is called the mosaic theory. The idea being that if the government has enough information about real-time movements of individuals, does that constitute an unreasonable search under the Fourth Amendment? So this is only dicta, but it shows that the court is thinking about it, and it bears mentioning in this discussion as well. So there are many other issues that could be discussed and other tendrils for discussion coming out of this, but I'll hold further comments and we'll take questions in order to make time for the other testifier.
Thank you, Mr. Ealing. I think I'll ask our members to hold their questions until we hear from the next testifier. Commander Gerlicher. Welcome to the committee. We are trying to figure out what all this new technology is all about, and we understand that law enforcement has used some of it currently, and we'd love to hear your comments.
Sure, thank you,
Would
Senator.
you identify yourself for the record?
Thank you. So my name is Scott Gerlich. I'm a commander with the Minneapolis Police Department, and my position is I oversee our Special Operations and Intelligence Division. So some of my folks are tasked with helping to solve crimes using a variety of methods to include technology. So I'm going to preface my remarks first by saying the MPD currently does not have, and we're really not currently in the market for any facial recognition or artificial intelligence technology. Certainly, like all of you, we're aware that it exists. And, you know, having said that, we don't necessarily have a strong opinion per se on the technology. I will say that certainly there are some advantages to things like facial recognition as it relates specifically to solving crimes. And having said that, I'm well aware of the issues. I think we're all aware of the issues, how it can be used. As was referenced, these systems can be used either with an unknown subject querying into a database of known subjects, or, as was referenced, a known subject querying into a camera system or a live system to see if that person has been out on the streets or what have you. As a primary law enforcement tool, I see facial recognition's biggest value is to have that, trying to identify an unknown subject. If I am investigating a serious crime, a rape, a homicide, and all that I have is a grainy photograph of an individual, if a piece of technology can help me identify that to include facial recognition, I think that's a positive thing. Having said that, we all, I think, understand the limitations of this technology. And currently, facial recognition is not a perfect system, not even close to perfect. Coming up with a match on facial recognition would never constitute currently any grounds for probable cause for an arrest. It's really nothing more than any other investigative tool or lead that may lead you in the right direction to make further identification of a possible suspect in a crime. And I think, having said that, an agency like Minneapolis, if we were ever get a facial recognition system, that's something that we would want to look at very closely, as well as implement common sense policies in conjunction certainly with our elected officials and our community as it relates to things like access control. Who within a department would have access to this? Another example is our license plate readers that we do have in Minneapolis. It's a very small group of intelligence analysts that really have access to that data. It's not the entire department. The types of crimes that these technologies can be used for. In the case of facial recognition or other types of technologies, you know, we potentially would look at only using it for the most serious types of offenses, not to try to find out who was jaywalking at 5th and Hennepin, but who potentially did a rape or a homicide. Reiterating things like penalties for misuse. We talked about restricting access, using it for passive versus active monitoring, as I talked about looking at an unknown subject querying to a known database, potentially not using it on live images in order to try to track people. As far as databases goes, that's the other limitation that these systems have, of course, is they need to ping out to a database of people. And as it relates to government, the really two main databases out there that I'm aware of are driver's license photos and then booking photos from jails, right? I'm sure there's other privately held databases out there. I don't know what those might be, but those are the sorts of databases that you would need to try to run a potential picture on to see if you come up with a match. And as you probably know, these systems might come back with 15, 20, 50 possible matches, none of whom may be the subject you're looking for. But that's where the investigative work comes in. You look at, well, yes, this occurred in Minneapolis, but now it matched to this person who lives in Virginia, Minnesota. Okay, scratch that person. So it's, I think, easy then to try to whittle that down and see if there's ways to further narrow your search, just as you would if you're looking for a specific type of vehicle that's out there. Trying to use those investigative tools to whittle it down, but not alone to constitute any sort of arrest. So those are just some thoughts that we have been thinking about in Minneapolis. And having said that, certainly happy to entertain any questions that you all may have.
All right, thank you. Any questions? Representative Scott.
Thank you, Mr. Chair, and thank you for coming to both of the testifiers. And my first one would be to, is it Gerlich or Ehrlich?
Gerlicher.
Gerlicher.
Yes.
Okay, very good. To the commander, as far as a database goes, if you could you add to, let's say, a driver's license photo database or some other database with facial images, can you add to that by grabbing images off of social media like Facebook and Instagram? Could you populate a database by grabbing those images?
Commander.
Mr. Chair, Representative Scott, I don't know the technology doing that, but I suppose an entity, if they had access to the driver's license database at the state of Minnesota, for example, I don't think a government database or like a city like Minneapolis could do that, because we would be pinging into an already existing system, not downloading all the photos. It would. That's my understanding of the technology, but I suppose if those images were made available publicly, more often than not, you'd have a company that would compile a list of photos that are in the public realm that potentially could be used for matches. Does that answer your question?
Representative Scott.
Yeah, I mean, from your perspective, I guess it's not definitive if we know the answer to that question or not. Let's see. I guess my next questions would probably be to Mr. Ehling. In the places where facial recognition technology has been outlawed or prohibited, like San Francisco, is that just by it's outlying that for government uses, or I'm assuming it's only government uses, it's not private sector? Do the Walmarts and the Targets still allow that sort of technology? Are they allowed to have that technology?
Thank you, Thank you, Representative Scott. I've only read the San Francisco ordinance with any level of detail, and that ordinance bans the use of facial recognition software by the city of San Francisco, so it doesn't touch the private sector.
Okay, thank you. And then have there been, thank you, Mr. Chair. Mr. Ehling, you mentioned a couple of case laws, but so far there hasn't really been any case law that's challenging facial recognition technology to your knowledge?
Mr. Ehling.
Representative Scott, I don't believe there is anything definitive in case law about this yet. It's still developing, and you can see the tendrils out there in other cases. There's an interesting case that's not on facial recognition, but it's proceeding, I can't remember what state, but there's a case in which the question before the court was, is a warrant required to allow the police to access a publicly available DNA database? So a DNA database where you can go on and search for your grandparents as an individual, but the question was, did the police need a warrant to conduct that same activity? And I believe the district court held that they did in that particular case. So it's a little outside of the scope, but you can see the parallels.
Right, sure. Okay, thank you.
Thank you. Any other questions? I have a couple questions. Commander, I don't know if we have the infrastructure established, but let's say your agency was looking for a suspect, and there might be an indication that that individual might be in a highly populated area. With facial recognition, could one fly over in a drone, let's say a state fairgrounds or a sports stadium, and pick that individual out of that crowd? Are we at that point of technology now?
Mr. Chair, not to my knowledge. I'm not aware that that type of system exists, but again, I'm not an expert on what technology may be out there currently, but that's not something we've ever used or have been made aware of.
Yeah. I know that our discussion is kind of focused more on government use of facial data, but more and more corporations are collecting that type of data now. And you only need to look at your cell phone. You can access the operation of your cell phone by a fingerprint, and now it's going, new technology is getting to the point where you allow the camera to recognize you as the user, and then it'll open the telephone up for your use. But someone in that company that owns that sold that phone has a collection of photos of tens of thousands of individuals, perhaps even millions in the future. And I don't even know if you can if you'll have the option of saying no to that future technology and that requirement. So if anyone has to use a phone, they have to give them your image. Mr. Ealing, do you know if there's any states that have any legislation that would prevent corporations from sharing data such as that? Or is it more, do they even ask a question and giving the public the option to step away from that use? Mr. Ealing.
Thank you, Mr. Chairman. I can't say that I have looked in any comprehensive way at what individual states have done in regard to that private sector regulation. I know that has been discussed by several states, and there have been regulations that have been talked about, and the data companies, their position is that they try to, and it's happened, those regulatory efforts have not happened in this state that I'm aware of, but I know that large data companies have come to Minnesota when we've tried to regulate aspects of computer technology use that might go outside of the state of Minnesota. We want to regulate its use here. The companies come and try to make an argument that this is a federal question and states should not get involved in it. So that's the response that a lot of these companies will bring to bear on this kind of regulation. But it's an open and pressing question whether that sort of regulation should exist, and it gets to questions of notification. Are consumers truly notified about how this technology and the data that's being collected is going to be used both now and in the future? Because we've seen certain companies like Facebook gather data, tell users that it's going to be used for one purpose, then they change their policies and it's used for another purpose. So those are open regulatory questions at whatever level they get decided on.
Representative Scott.
Thank you, Mr. Chair. Real quick to that issue, I was reading up on the California Consumer Protection Act yesterday, and what they've done in California is they basically have, for anyone that's 16 or over, you basically have an opt-out. So when you can find out which companies are looking at your private information, and biometrics is included in that. So your face and your fingerprints and whatever else is included in that information. And so the consumer has the ability to say, like, I suppose technically for a particular application on your phone, you could opt out of having that information shared. You can opt out of having, when you're surfing the web, you can opt out of having that information shared or shared with other entities. So I would think that maybe we could look at California to see what they're doing in that area, if you're interested to see what other states are doing.
Mr. Ealing?
Representative Scott, a follow-up thought on that. One interesting area to look at in this whole question of the interaction between government entities and private entities that hold large data databases is how some private entities are marketing these large databases they collect to government entities as a way of trying to get around people having questions about the government maintaining a large database of information. They collect it in the private sector and then offer it up to the government. I happened to be in Baltimore a couple weeks ago for work, and I opened up the Baltimore Sun, and one of the cover stories was about a private company that was proposing to conduct aerial surveillance with high-resolution cameras of the entire city of Baltimore 24 hours a day, maintain that data, and then make it available to the police department if they wanted to access it. So those private sector, public center interactions are something that the Minnesota legislature could certainly regulate. They could regulate around how public sector entities are interacting with private vendors, for instance.
Oh, Representative Lucero.
Thank you, Mr. Chair. And to Mr. Ealing, question here. I don't know if you plan to continue working your way down the list here, but in case you don't, I'm just going to ask you a question on something that's near the bottom. And you have automated decision-making in government. I'm very intrigued by that. If you could expand upon that and give some examples, because especially when combined with artificial intelligence, which continues to increase in its capabilities, automated decision-making by government, when you combine facial recognition or other biometric, I think is a huge potential threat to our liberty. So if you could just expand upon that, thank you.
Mr. Ealing.
Thank you, Representative Lucero. We bring it up because it's an adjunct to this discussion, but as you recognize, it's a much bigger discussion on its own. And so it gets to this question of, as commercially available artificial intelligence systems come on the market, and they are utilized by the government to make determinations that impact the real lives of citizens. So you could be looking at artificial intelligence systems that are making determinations around probation or the distribution of healthcare benefits or any other kind of determination that's today made by a government official. If you automate that, it opens up a couple different lines of inquiry. So one is, how do we verify how the decision was made? So right now, the Data Practices Act is a tool to be able to verify how decisions are made by giving a citizen access to go back and look at the paper record, the documentary record created by a government official making a decision. So you have access to that today through the Data Practices Act. If you replace that activity with a computerized activity, and you're buying that capability from a private sector vendor, that computer code is going to be exempt from disclosure under the Data Practices Act. The computer code would be what you need to know or need to have access to understand how the process worked. That kind of information is trade secret information under the Data Practices Act today. So if you don't have access to it, you can't understand how a decision affecting your life has come to be. So that's a major question going forward. The other set of questions come to, if you either don't have access to the computer code or you can't figure out the computer code, even if you did have access to it, are there other steps the state should take to put in guardrails around the use of automated decision making? So it gets to something that Commander Gerlicher had talked about. Do you have a government official review the outcome of an automated process so that there is some person who is accountable in the system to authenticate that decision and take it to the next step? So that's another set of questions about how do government entities and their employees use these systems and who's ultimately accountable for their decisions.
Representative Lucero.
Thank you, Mr. Chair. And then this is just a comment more than a question, but part of the earlier conversation involved ALPR, and we had that conversation here at the legislature several years ago in which we put controls in place and we put maximum retention periods in place before things had to be, or data had to be purged. But then part of the conversation today involved the camera system that some municipalities are putting in here in the state of Minnesota, some police departments. The same principle applies. Instead of having fixed cameras that are capturing license plates and then retaining that data with the ability then to correlate people's movements over time, it'd be the same principle of a fixed camera capturing people now on a sidewalk or other, so it's not involving license plates, but it's involving people's faces. Do we have anything, so this is a question, Mr. Chair, for Mr. Illing, are you aware of anything on the books now that any regulation or statute that would prohibit a government, local government from capturing faces at a fixed camera and then retaining that information over time, which then can be used, as we saw demonstrated with ALPR, people's movements?
Representative Lucero, I'm not aware of any policy guidance on that question currently. But there are retention schedules for the maintenance of municipal video recordings, and those vary by municipality.
Actually, Mr. Chair,
Representative Lucero.
I'll throw it out to both actually testifiers, that question. The question is, are you aware of anything that would prohibit right now? Are there controls in place in relation to this, whether or not Minneapolis is doing this now, but another department could be doing this now, or Minneapolis could do this in the future in the absence of controls in place with fixed cameras capturing people's faces with and then retaining that information over time?
Yes, Representative, my understanding of the laws that any data maintained by a government jurisdiction has to have an approved data retention schedule, state approved. In the case of Minneapolis, we have that for all the data that we have in our possession. We have over 240 public safety cameras throughout the city of Minneapolis, and we do have a state approved retention schedule of 14 days. So all those images on our cameras are only maintained for 14 days, at which time they are automatically erased and overwritten. And that has been approved by the state of Minnesota. And I would venture to guess that any agency out there that has those cameras would have to go through the same process. Now, they could certainly choose to keep those images longer. I don't know that there's specific restrictions as to the state only allows them for 14 or 90 days or 3 years. But in Minneapolis, we chose and proposed to keep those for 14 days only.
Are there any other questions? I did have one question, Commander. Is there a way, or let me rephrase it, has there been any discussion by your department that uses facial recognition about the concern they might have about other people outside of a police agency using a drone or using a camera to accumulate facial recognition images of your officers, and then with that information they could track eventually an address, a location, a car that they would drive? Is there any concern about the safety of officers in the misuse of facial recognition by a private entity?
No, I'm not aware of any of those types of conversations ever having come up as it relates to drones or facial recognition. I think certainly just in general, police officers are citizens too, so we share the concerns of the general public as it relates to use of technology and being able to track our positions as citizens, but I'm not aware of anything like you're suggesting, Senator.
Yeah, I know that in some states and even in Minnesota, one can get your property records sealed so that your identity as a property owner would not be revealed to a general public information search. A lot of police officers, I believe, at least in other states, maybe here, avail themselves of that option so as not to create any opportunity for misuse or some type of revenge motive on a police officer or their families. I'm just wondering, with this new technology, it opens the door in a lot of creative ways, and we sometimes don't always focus on that as we're writing law. So it's good to have a real good airing on this issue. I want to thank our testifiers for coming today. We greatly appreciate it as we begin to open this subject area up. There is in your packets, members, review and comment by a citizen lobbyist, Mr. Neumeister. He wanted us to review that. And, one other thing, we will be discussing this in the future, at future Data Practice Commission meetings. If there's anyone in the audience, either a citizen or a lobbyist who represents private sector or public entity, we invite them to call our office and get on the schedule to give us their perspective and help us get a little more definition to how facial recognition can be affected and how we can responsibly address this new technology in law. I have one other testifier that's on our docket, so I'm going to call Mr. Heller to come forward. Gentlemen, if you wish, you could leave if you want to. Mr. Heller's got the podium right now.
Excuse me, Chair, I'd ask him to stay if, with your permission. It has to do with what they testified, and I think what's relevant, what I will bring up, will specifically relevant to these individuals, only if the Chair allows them to yield to the question.
State that again, Mr. Heller. Did you want to ask these testifiers questions?
Right, but I want to respect that it's the Chair that decides any questions that are answered publicly here.
Mr. Heller, we're not going to honor that. You're here to make comment on either cloud-based data language or facial recognition technology.
That's correct.
And so I'll let you proceed. We're not in a position to ask questions of the testifiers.
It's always at the discretion of the Chair. Thank you, Chair.
Please proceed.
I have some handouts here, Chair, if you could provide those, so.
Right.
Or one handout, two-sided.
All right.
My name is Rick Keller, unofficial representative, twice exceptional people with print disabilities. Come to testify today at the Subcommittee on Data Practice on November 7th, 2019, specifically.
Could you pull the microphone up close to you, Mr. Heller? It's hard for me to hear you.
Specifically on recognition software and some of the handouts and discussion I've had with members that were just here at the table. I am one of the shareholders in the state of Minnesota, unofficially represented twice exceptional Minnesota Statute 120B15, gifted and talented program and statute, and unofficially represent the people with print disabilities found in the Higher Education Opportunity Act of 2008, as well as an IDEA Act of 2004. Starting with your own documents, since I gave you a single handout specifically, I wrote on the Pacific sheet, NBC Now, which is the news stream. Where's the link on stream? It's not currently on here. If you're going to have a presentation, I ask that you put that link on there since you're going to utilize that. Secondly, the agenda from the last meeting is not accurate, frankly, specifically the draft minutes. I had a handout. It doesn't say I had a handout. This specifically came from the prior Data Practice Commission, which is currently online. As you already approved those minutes, you need to rescind and put that in there since I had a handout, and I provided that handout. And it is recognized as an official document. And thirdly, the reason I have marked video, I expressed at the last meeting, I appreciate captioning, which you currently have with this meeting. However, when I check that, caption is not available and that stream is not available. Only your audio. It is out of compliance with 88A of 2008 regarding supplemental aid and services using assistive technology. This is not fully transparent for the public at large, specifically for the twice exceptional people with print disabilities. Now, getting back to one of the correspondence from Mr. Rich Neumeister. On the third paragraph, he used the word digitization. In the sixth paragraph, I reviewed that article. By the way, their article is in the cloud, and it's in the image format. I spoke at the last meeting that when we get into the cloud, I did speak at the meeting about Minute and now being allowed to use the cloud, which is a state agency. How are we applying web content accessibility guidelines in 508 to data practice? Data practice law is, again, I expressed before, does not get into what electronic versus digital. If we're going to be into the workplace, called the Workforce Innovation Opportunity Act, the 2014 Act of Congress, how are we assuring that these documents that are being created and stored are fully accessible for everybody, that they all have access in the workplace to access this information? If we don't apply it, we want to apply it to the municipal legislature, which you did this year, which was originally Senate File 1727, went into the special session, which became law. However, as I expressed before, took the funding away and moved the working group about 2 years. This committee could have a rule, create their own rule for digital accessibility. They could start that process. So the piece of this is now going, if you're aware about the people gathering digital faces, I don't know if you're aware of this, but third parties currently privately in the metro area are pinging phones. And law enforcement are utilizing those phones. The question would have been to Minneapolis, would have been a two-part question. Are they using those services? Because that all has to do with bypassing or justifying court orders process, such as a warrant, about getting access to people's personal information on their phones, so they don't have to get a warrant. Another piece of that is the Super Bowl would have been to the commander. They left behind a great amount of equipment behind, funding on security in the metro, you know. And frankly, how secure is that information? And are they using that information? Is that separate part of their system? And are they storing this information, pieces of it, even though the cameras erase it? Are they receiving pieces into their personal files as they continue investigations? So really, these are questions you could ask or query on, or have your people look at. This whole thing about being able to verify by access, if it's not searchable, frankly, how can you analyze it? Just like expressed today, Facebook is currently under the magnifying glass by Congress. They own Twitter. They're gathering information. The phone companies have terms and conditions. You agree to those terms and conditions, you're opting in. How do people understand that they're willing to give that information away freely? And here's one for Mr. Clausen. One on FERPA, on students in the school systems. What are they doing with that information? Are they doing facial recognition there? They're certainly collecting their information. That's currently another discussion in Congress. We need to be proactive on this process. And once again, regarding SC F5645-2, you were correct at the last meeting when you said it's not a bill under 1 minute and 1 hour, 3 minutes, and 50 seconds under the stream. You did say that. And the document I provided said documents don't become fully accessible at the Minnesota legislature until they get exhibited on the floor. Yet we want to have transparency. These documents aren't fully accessible. Once again, I appreciate your time, considerations, and open any questions if you have any.
Thank you, Mr. Heller. I did want to make one comment by your words saying we need to be proactive. That's exactly what we're doing in this commission. We're asking questions. We're trying to understand a new technology. We don't have all the questions because we don't, and we're trying to seek answers. You did raise a few questions that I'm sure we will follow up on in regard to the technology that is coming on our society. But nevertheless, we are being proactive, Mr. Heller. And I want to thank you for any assistance you can give us in these specific areas.
Thank you, Chair, and it's not a thank you, but it's how we apply civic engagement with the citizens and are more effective, and I appreciate your time.
All right. Is there any other comment by our members? Hearing none, our business is concluded. And again, I make the invitation to anyone who wishes to join us in discussion in the future, whether it's the private sector or a public sector participation, it would be greatly encouraged. We stand in adjournment.